Andarki Namaskaram. Welcome to TAGCA, Telugu Association of Greater Charlotte Area's Immigration Webinar. I am Satish Dhanamudi, President of TAGCA. Today, our speaker is Lakshmi Challa Garu, who is the Managing Attorney of Challa Law Group. Lakshmi Garu has practiced immigration law exclusively for more than 20 years at her law firm headquartered in Richmond, Virginia. She obtained a law degree from the University of Richmond in 1995 and BA degree from Andhra University, India in 1988. She's involved in various volunteer efforts to help the community and a recipient of several awards in her industry throughout her career. Before we start the webinar, I'd just like to provide a brief update on the format. Today's webinar will be conducted in two parts. First part is an information session on the presidential proclamation of immigration restrictions, student restrictions, and other topics, which Lakshmi Garu will cover. And second, we'll open it up for Q&A. There are two ways of asking questions. First, Miru chat window, you can type in your question and I can ask the question on your behalf to Lakshmi Garu. Or you can click on the raise your hand button and we will unmute you so you can directly ask the question to Lakshmi Garu. With that said, I'd like to hand it over to Lakshmi Garu to start the information session.
Excellent, excellent. Mi andarki namaskaralu. Thank you so much, Telugu Association of the Charlotte area, for inviting me to talk to you about a really critical topic. I hope you all are safe and incorporating safe, not socially distant practices, but physically distant practices. In the midst of this COVID pandemic, we have been bombarded with a number of immigration restrictions. So President Trump is building that wall after all, but he's doing it through, executive orders and USCIS adjudications. And anyone that's familiar with immigration has known that since 2016, the RFE rates, denial rates all around the board have increased. There's been delayed in processing. So in the midst of all of this, we've been hit with certain informational bombs about new restrictions. And my goal today is to give you not only the knowledge that you need to navigate through these challenges, but hopefully give you some tips and strategies that you can incorporate so you can reach your immigration goal. So with that, I'm gonna pull up my PowerPoint. Okay, there we go. Okay. So can you all see the PowerPoint? Okay? Yes. Okay, good, good. So to get started, today we're gonna cover a number of things. I wanted to go over some basics first to talk about, I think a lot of times people get confused with status and visa, authorized stay, maintenance of status, and legal status. So I wanted to go over those things because they're really critical when you're trying to understand what options or what strategies you need to incorporate to overcome the latest challenges. Just to give you a heads up in our efforts to try to get information out to the community as much as possible, what we've been doing is we have been hosting a bunch of webinars every Wednesday at 12 o'clock Eastern Standard Time to take a deep dive into various topics that affect people. And we have those recorded sessions on our YouTube channel. So check that out if you want to understand things about remote work, perm processing, a number of topics, through these restrictions in the COVID time. First, visa versus stay versus status. Now, the interesting thing is you only need a visa to end. Visa is an entry document. You don't need a visa to stay in the United States. You just need a visa to enter the United States. So the expiration of your visa in no way impacts your current status, even if you change statuses in the United States. Now, this, I would say, is the most important document you have, your I-94 card. You get your I-94 card either when you enter the United States, and it's issued electronically by the Customs and Border Protection. And a lot of people don't, because they don't hand it to you physically, a lot of folks don't look at it till much later. I would caution you to, as soon as it's feasible, to go and print out your I-94 card every time you enter. The reason is there are times where the Customs and Border Patrol make a mistake. And the sooner that you are able to review that and find the mistake, the easier it is going to be to correct it. So the I-94 card dictates the period that you can stay in the United States. And there are some periods that are authorized stay, which we'll go over in just a second. So what is your status? How do you maintain lawful status? So that really depends. It depends on the type of classification you're on. But one thing that's very clear is that a non-immigrant can only engage in activities that are consistent with their current status. And so each non-immigrant category has different requirements, different limitations, different restrictions, and different periods of stay. So let's start with F1 students. For F1 students to maintain status, they have to take a full-time course load or authorized, they have to be an authorized practical training. And then there's a 60-day grace period. Now, the full-time course load prior to March 2020 meant that you could only take one online class with your full-time course load. Everything else had to be in-person classroom instruction. So, as I said, you could only take one-time course load in order to be maintenance of status. And then, you're allowed curricular practical training, but typically in order to avail yourself of curricular practical training, you would have had to have worked for one full academic year. Graduate students are exempt from that. And, you have to have an employer for CPT. You can't be self-employed for that. You can be self-employed for STEM OPT. That's the only exception to that. And the employment must be clearly related to your field of study. And you must have your I-20 endorsed. And I meant the OPT allows for self-employment. STEM OPT does not. But you have to have, for curricular practical training, we've had a number of students who started working, but they didn't get their I-20 endorsed by their, student advisor. Designated student advisor at the university. And the reason why is if you don't do that, what happens is that endorsement on your I-20 is the documentation that you present for your I-9. I-9 is what every employer has to undertake for any employee, not just employees that are on different visas, but for every employee to make sure that they are in an authorized, work authorized status. So secondly, unemployment on OPT. So those that are on OPT, you can have 90 days of aggregate unemployment. And that's really important because we've seen there have been some issues where students during this period have been getting training, right? So training in and of itself is not employment. And with a couple of companies that are, I guess, somehow related, they've been offering training for the student to pay for it. And then they say that they'll place the student. There have been some issues where the Department of State has found that those particular activities may be that the student is paying, not for the training, but for fraudulent documents for placement. So remember, it is 90 days on OPT and it's 150 days on STEM OPT. For those of you who don't know, an F1 student typically gets a 1-year optional practical training after they graduate from their program. Now, if you're in a STEM-related field, you get an additional 2 years on optional practical training. And as I said, there was a typo in the previous slide where I said, so for OPT, you can be self-employed. For STEM OPT, you have to submit a training program that is basically a document that you submit to your DSO, but it is between the student, the employer, and the school. And it has to outline how you're going to be supervised, and that it is actual training. And I say that, again, another issue we've been seeing is when students on STEM OPT are placed at a third-party site, there has to be some mechanism in which there is oversight of their work, where the training takes place. So employers have to communicate with that student. I would do that, make sure that there's documentation of that on a weekly basis. Otherwise, you are not truly training the employee and you're just using them for labor. And that's not consistent with the program. So those are the couple of things that I wanted to kind of highlight. The other issue we see a lot is students that do day one CPT with the same degree. The regulations state that a student is authorized for practical training for 12 months practical training when he graduates into a higher degree. That means bachelor's degree to master's, master's degree to doctorate. But if you're going from master's to master's, you know, and you've undertaken day one CPT, and actually that's the reason why you took up this master's program, you won't see a problem at that moment. But when you file for an H-1B, we're seeing a lot of requests for evidence stating this very issue, that the student has rolled in a second master's with the same degree program. So that could be problematic, and that's something you want to kind of keep in mind. H-1B workers, what constitutes their status? Excuse me. H-1B workers are initially supposed to file, the employer files a labor condition application with the Department of Labor. So with H-1Bs, you're dealing with Department of Labor and you're dealing with USCIS, both agencies. So the Department of Labor, what they're concerned about is they want to make sure that you're not displacing US workers by providing cheap foreign labor, that there's no strike and lockout, and that you're adhering to the terms and conditions outlined. So what do they mean by you're not replacing US workers with cheap foreign labor? Well, they have a process. They have what's called a prevailing wage, which is in their online wage library. And they've got 4 levels on the prevailing wage. And so, you know, the employer, depending upon the type of work the employee is doing, so it's not the salary, but it's the type of work. And it's outlined within the prevailing wage guidelines what level it should be. And if you remember that, I think it was in 2017 that the memo came out about level 1 for H-1Bs, that it shouldn't be a level 1. I think in some instances that can be argued because these people are graduating, and we've used that. I said if a law student graduates, passes the bar, and starts working for our office, they're going to be a level 1. They're going to be supervised. They're not working independently. So these are all the things that you can say to boost that argument. But effectively, there are 4 levels, and there's a wage associated with each level, and it's geographically specific. So the employer affirms that they will be paying that wage that's outlined in the Department of Labor for, you know, whatever it's annualized on a monthly basis. So whenever you, and where that comes up otherwise is when you file for a change of status or an extension of status or your adjustment of status, they'll look for pay stubs to ensure that you've maintained status during that time. So being paid is evidence of maintaining your status. There's a no benching provision, so employers cannot place employees on unproductive status without paying them. this came out during the Clinton administration through the IRA regulations. So the only exception to that is if the employee takes personal leave. So even during COVID, they allowed for remote work, assuming that it was consistent with the LCA that was on file. But they said that, you know, and a lot of employers would say, well, can't the employee take personal leave? Well, personal leave is not defined by just saying personal leave. It has to be consistent with whatever the company policy is on personal leave. So, and you should have that well documented, because if you're ever audited, and if you're audited on issues relating to H-1Bs, it would be through the Department of Labor. And I've represented a number of companies that I wasn't doing the immigration work for across the United States on Department of Labor audits. And so what they will do is they will look at your public access file, your H-1B petitions, and they'll cross-check that with your payroll. And so anytime there's a lapse in pay, you'll have to show them documentation, you know, evidence of that personal leave. The other exception is this 60-day grace period that's been allotted for H-1B workers. One thing I want to say about the 60-day grace period, you have to remember that the grace period is not guaranteed. There is, you know, the only time you will know if the USCIS will allow for the grace period is when you file for a change of status or perhaps a change of employer during your 60-day H-1B grace period, because they have the regulations outline discretion through the USCIS. So they have the ability to approve or not approve your grace period, which is not very settling, especially in times like this. The other thing I wanted to outline is, before we go into thoughts for developing strategies, is when you're filing for, let me go back. When you are filing for an H-1B amended, let's say you're changing employers, you can do that through, everyone knows the portability of H-1Bs, that, you know, as long as when you file for a change of employer, as long as it's received by the USCIS, the petition for change of employment, then you can begin work for the employer. And some of the issues that relate to that are, you know, when is it deemed received? So it can be received if it is, you know, some employers are risk averse. So they want to wait for the approval notice. Some employers have, you know, a little bit of risk tolerance. So when the receipt notice comes in, they're willing to start work. There are some employers that have a very high risk tolerance, so they're okay with the FedEx confirmation that the USCIS received the petition. So during that time, you're permitted to work for your new employer, and you would submit your previous I-94 card and some sort of proof that your petition has been received by the USCIS, i.e. FedEx confirmation, receipt notice, or, you know, you'll have the actual approval notice. When you're filing an extension of your H-1B status, it's important to note that even though you don't have, you know, you may not have an approval immediately because you're not filing in premium, that, you know, you will have, you know, that there will be a time lag. So when you file an extension, the I-9 regulations state that just filing it prior to your expiration allows you to have 240 days of work authorized status while the petition is pending. And that is only in place for extensions. So that is actually something good to know, because a lot of people get worried that they filed and they think that because they're not leveraging premium processing, that they're out of status. No, you actually get 240 days in which you can continue working in the United States based on that extension. And then one of the things, as I'm talking about extension of status, change of status, it's really important that the time frame that you keep in mind is filing something prior to the expiration of your current status. You don't want to file after you've expired unless you're filing within the designated grace periods. That's really important. And so some thoughts for developing strategies on H-1Bs. You know that the H-1B is only allotted for a maximum of 6 years. And the exception to that, there are actually two exceptions, and everyone keeps forgetting the first one. If your perm and I-140 combined has been pending for more than 1 year, you can get 1-year extensions on that. You have to stick with the same employer because that's part of the whole I-140 process. But the other exception to that is if the I-140 is approved. Now, when the I-140 is approved, some great things happen. Aside from the H-4 being eligible for an EAD, you also have the ability to maintain your priority date. So if you do change employers, you're able to retain the priority date. You have to go through the permanent residence process again, but with the backlog you have for India, that's really not going to hurt you at all. And the other thing is you get 3-year extensions. Now you get those 3-year extensions even if you change employers. And so what a lot of people don't recognize or don't realize, and it's really important with the new immigration restrictions, is if you've got a valid H-1B visa in your passport, then you don't have to get a new visa even if you change employers. And that's really important to know given the current restrictions. So these are some thoughts I wanted to throw out there, in developing strategies. And a lot of people have asked me, do you think we should continue with the permanent residence process? And I said, absolutely. This is the best time, if ever, to make sure you're going through the permanent residence process because it offers you greater protections down the road. So we're talking about restrictions. The president's authority, 212F, is what grants the president immense authority to prohibit the entry. Okay, so it's the entry of individuals. And so the president really, it's beyond his authority to do a lot independently through executive order on people who are in the United States. The USCIS can do that. But for the president, he can only bar the entry. And typically, if you look at all the cases that have upheld the president's authority, it's usually been in issues of national security. So it's going to be interesting to see, it hasn't been challenged yet legally, but I suspect at some point it will be because the president in this particular executive order has stated that it's not for national security, but it's for the economy. And I think if you look at the nuances of the executive order, it's counterintuitive to what they're saying that the purpose is. So it's going to be interesting to see how this plays out. But the effective period was, June 24th at midnight, and it's supposed to be effective till December 31st, 2020, which at that time they'll consider whether they need to continue it. Now, not all classifications were impacted by the president's proclamation. It's only H, H-2Bs, Ls, and Js, and their dependents, okay? But not all H's, L's, and J's are affected by it. And what I mean by that is it's only if the individual is outside the United States. Remember I said presidential proclamation, president's authority is limited to entry. So it only affects people who are outside the United States and they are not in possession of a valid visa. So if they have an H-1B visa, they're not prohibited from coming in on that. If they have a travel document like a advanced parole. They're not prohibited from coming in on that. So it's only those individuals on H, H-2B, L, and J, and their dependents who are not in possession of a valid visa. So for example, if your spouse had an H-4 visa, but subsequently changed their status to an H-1B, and for some reason had to go outside the United States, and now they're stuck because they can't get their H-1B processed, they can return on the H-4 visa and then file for a change of status in the US. That's permitted. And with the consulates closed, and we're seeing a surge in cases, not only in the United States, but also in India. We don't know how long they will be closed. I know they're taking appointments for September and October, but we'll really have to see, how this pandemic plays out, to get a new visa. So who are exempted? So it's lawful permanent residents that are exempted, and spouse and children of US citizens, and folks that are trying to come in to provide temporary services to assist the food chain, food supply chain, and any individuals whose entry would be in the national interest. So it's really interesting that they place that in there. Remember that that's also a deferential term as to what is deemed in the national interest. So there is a national interest waiver for permanent residents. So if you utilize, that definition, you would have to really, show how your work is furthering the national interest of the United States. And remember, it's a deferential. That means it's based on a determination by the Secretary of Homeland Security. So we don't know if they're really, even though they have that in there, whether they're going to really apply it strictly or liberally. So we'll have to wait and see how that plays out. So just as we were trying to get our head around the restrictions imposed in the presidential proclamation, the USCIS issued a temporary final rule. Now, remember I told you the president through 212F doesn't have the authority to direct or restrict folks in the United States, foreign nationals in the United States, but they're able to do that through the USCIS. So the USCIS issued a temporary rule suspending F1 students from taking full-time online courses. Now, previously, I told you that the rule was that foreign students could only take one online course. In March of 2020, due to the COVID pandemic, the USCIS actually made a modification, allowing F1 students to take full-time courses. So it's important to kind of know what the major tenets of this rule is. The US Department will not issue visas for students who demonstrate that they're taking totally online courses. And even if they have a visa and they're able to enter, the Border and Protection will not permit them to enter the United States. Active students who are currently enrolled in programs, they're okay to continue the program, an online program throughout the summer, but in the fall of 2020, they can't take all online classes. So if the institution is attending school, like I said, they're bound by the current regulation of one online class, but there's an exception. It's called the hybrid model. So the hybrid model is when there are some online classes and some in-person classes. And we're seeing a lot of schools trying to, figure out how they can incorporate that. Because now, instead of keeping the health and safety as a paramount issue for how they conduct classes, they have to worry about their international student community and trying to protect their interests as well. So the hybrid model, you're allowed to take more than one online class. So these schools have to report to SVP that the student is not taking entirely online classes this semester, and the student's taking minimal number of online classes to make normal progression. And so what's been bizarre is the reporting. Schools that will totally be online are supposed to notify SEVP by Wednesday, July 15th, which is, you know, the rule just came out July 6th. So schools still grappling with it have to figure out whether they're going to, especially the ones that previously reported they were going to do online classes, what they're going to do now. Do they report by July 15th they're going to do online, or do they try to figure out how to put together a hybrid model when that was not something they were prepared to do? So the schools that are offering the hybrid model have to report that by August 1st, and they've got to reissue all I-20s. And in the remarks field, they've got to clearly affirm that they are not operating totally online and the student's not taking on an online course load totally, but just that they're taking a minimum number for normal progress in their degree. So they don't really outline how many online, how many in-person you have to take, but an in-person portion of that is mandatory. So under the FAQs that the SEVP issued, they stated that the students that are currently taking online courses for the summer are permitted to take those courses through the summer program. That's fine. Now, and the students are permitted to attend and take these classes, but they're, you know, if a student returns to their home country, they are permitted to take the online classes and have their information stay in the SEVIS record system. So there would be an active foreign student, they'd just be taking their classes online overseas. For those individuals who were planning to come in fall of 2020 and their school is not taking online. So remember, the exceptions are either you're in an in-person program with only one online, or you're in a hybrid program with some online, some in-person, or they say you have the option to transfer to a school that is offering either the hybrid or in-person classes. But if you're in a situation where you can't transfer and you've already paid your SEVIS fee, they will not refund your fee. That's really nice of them. And that's because they're having a lot of issues with funding right now. But the one thing that was most troubling in the SEVP FAQs is the fact that they said, if the school initially says that they're doing hybrid and mid-semester, let's say, you know, the fall, the second wave of this COVID pandemic really flares up and the school decides to go totally online, at that time, the student either has to transfer to another school that offers in-person classes, or they have to depart the United States. I think that that is just one of the most horrific. Everything else was bad, I would say, but this is just really troubling from a health and safety and humanity perspective, that if it's so bad that the school is thinking about closing its operations because the fall flare-up, the second round of COVID-19, as everyone has predicted, really escalates. And we've not seen a slowdown, mind you, that the school has to really think hard before thinking about the health and welfare of the students, because all of a sudden they're foreign students who may be in the second, third, fourth year of their program, right? So they've already invested so much time and energy and money, would have to choose between transferring to another school or departing the United States. So that is really troubling. And that is why Harvard and MIT filed suit in the federal district court in Massachusetts. USC joined the lawsuit. And there are a number of schools, I think UNC's has a number of schools that have started, deciding upon the hybrid program. But a lot of these things that I've outlined is what's outlined in the suit. And the suit basically says that the USCIS, and I think this is the weaker argument in their lawsuit, if you had, for those, because we're doing these weekly webinars, when I started talking about the anticipated changes that would come up, I dedicated one of the webinars to talking about what the USCIS has to do when they're issuing a new rule. They have to go through a notice and comment period. And they have to wait 30 days for comment. So usually the change in rulemaking takes some time. If there is an emergency, they're allowed to go ahead and make modifications without going through that notice and comment. In this particular instance, they're not changing the rule, they're just withdrawing their modification. So the modification was a change in the rule, and they did that through emergency rulemaking because of the COVID pandemic. And what they're doing right now is they're just, revoking that temporary modification. So I don't think that the notice and comment argument is strong, but the other arguments are compelling, especially the one that relates to the health and welfare of the general student body at large. If mid-semester, these hybrid schools have to decide that they want to go all online because of the pandemic. So how this works is when a case is filed in federal court, the judge has the ability to enjoin, which means stop the USCIS from enforcing this rule. And of late, what federal district courts have been doing, they've been doing what's called a statewide injunction. So the injunction is filed, even though the case is filed in Massachusetts, the Massachusetts federal judge can issue a national or statewide injunction so that the entire United States, the USCIS, is precluded from enforcing that rule through the entire United States. So there's going to be a lot of challenges in Trump versus Hawaii, the Muslim ban, if you recall. The Supreme Court said that the president had great latitude in restricting the entry, but they also talked about issues relating to not really liking statewide injunctions. But they allowed that lawsuit, even though it was an executive order, and this is a USCIS challenge. In Trump versus Hawaii, it was originally stopped through a statewide injunction, but the Supreme Court stayed the injunction and allowed the lawsuit to go up. In other words, they said, no, the restriction is going to remain in place until it works its way up through the court. So we'll have to see how this plays out. So in the midst of COVID pandemic, a litany list of immigration restrictions, and the already delayed processing by the USCIS, they're out of money. I don't understand how. I'd really like to see how they're budgeting their resources, but they had requested emergency funds from Congress, and they plan to increase the fees by 10%. And if they don't, they're going to furlough at least 13,000 staff members. And if you are familiar with immigration, the processing times are record highs. And premium processing has just been reinstated in June, but we have found as soon as you upgrade your petition to premium processing, the very day it's received by the USCIS, they're issuing an RFE without even clearly reading the petition. And the reason is, remember, premium processing, you're paying that $1,440 to upgrade to premium for a 15-day processing. And if the USCIS doesn't process within 15 days, they have to refund your money. And so the craziest thing is the only way they can kind of stop the clock on that 15-day without refunding you your money is issue an RFE. So if you have received an RFE because your petition was upgraded to premium, don't worry. That doesn't necessarily mean the merits of your petition were in question. It just means that they didn't want to adhere to the 15 days rule. So I think this is a good time to, I know I went over a lot of information very fast, but I think it's a good time to go over any questions if anybody has any.
Yeah, Lakshmi Garu, we have a question from on chat from Neha Malkan. My daughter is US born. We are stuck in India with approved I-797 petition. Is there any scenario where we can go for H1 and H4 visa stamping and enter the US? Any possibility for further amendments to the proclamation to favor H visa?
Right. Till now, there haven't been any challenges that have been put in place. And actually, you know, I had been advising people since March because I knew that 212F barred entry. I'd been telling at least the people that have been listening to our webinars, don't travel. Because if you're here, there's limited things that the government can do. But if you're outside the United States, you know, you may not be able to come back in. But for right now, unfortunately, unless there is, you know, another visa classification you can come on, you know, I don't know if, you know, going to school is an issue, but then you'd have to find a school that's a hybrid school. The fact that your daughter is born in the US until she is, you know, an adult is really not going to help you in this particular instance. And so I would say stay tuned. We're keeping track of this, but for now, unfortunately, there is no mechanism. And I do want to say this because I know a lot of people are thinking about this. A lot of folks have asked me, what if I get a B1 visa or B2 visa and come to the United States? Because that's not one of the visas that are banned. Now remember, you probably won't get, if you're not already in possession of a visa, B1 and B2 visa, they're not taking appointments till purportedly September or October, number one. Number two, it's still not easy to travel because there's still a lot of country, not visa related, but country-based travel bans that are in place. But if anyone enters on a B1 visa, when you enter on a B1 visa, you're making an affirmation that you intend to return to your home country. That's implicit within that visa classification. If you change status within 60 days of entry, under President Trump, they issued some rulemaking saying that if you change status within 60 days, you will be deemed to have had a preconceived intent to change status in the US. So you can't do that at least within 60 days. After that, you're still going to have to overcome that issue of whether you had a preconceived intent when you entered. And remember, even if you have a valid visa, when you come to the port of entry, CBP can look up your immigration history, and they'll know you have an approved I-797, or you've had a previously approved H-1B or L, and they may. So unless you have a valid reason for coming in, and that's why I tell people the F1 is probably more, it is a more compelling way in which to come in, because if you take a 1-year master's program, one of those specialty masters, then at some point you can change status. But unfortunately, there's no way to get the H-1B stamping in your passport if you don't already have it.
All right. Lakshmi, we have one more question. Does this impact green card processing of anybody who's already going through the green card process?
No, no, there was some discussion. I think, I'm trying to remember there was some newspaper that reported that permanent residence processing was halted in the United States. But since then, that's been debunked. So no, your process will continue. Now, if these employees are furloughed, this is just USCIS. So if it's in labor right now, then, it shouldn't be impacted. But the USCIS with the furlough, if it's in the I-140 stage, that could have some impact unless you premium process it. And like I said before, I encourage people to file permanent residency now because you get greater protections if you do that.
And Lakshmi, are these restrictions only for this year?
Well, the proclamation says that it's valid until December 31st, 2020, but it can be extended. But I think November is going to decide for us whether it's going to be, what the outcome is going to be. Because in November, if the administration changes, I'm pretty sure that, under a Biden administration, you're not going to have these types of restrictions. And I had the great opportunity to meet, at that point, Vice President Biden in Charlotte. I had lunch with him in Charlotte many years ago. And, I think that we can expect everything to kind of change if that were to take place. But, in this day and age, I would not predict that anyone's going to win or anything's going to happen. A year ago, I would not have thought that we would be in the situation we're in right now. So, but I think that will depend on everything. And, the crazy thing about the proclamation is it bans Ls. And L is something that a lot of companies use, multinational companies use, to expand in the United States. So you're effectively stopping foreign direct investment from being infused into the US to create US jobs, using somebody else's money, another country's money, to stimulate your economy. So it doesn't make sense. And with the H-1Bs, a lot of them that are stuck in India that have been working for the employer, but perhaps didn't have a valid visa, their employers are allowing them to work in India. So they're working in India, getting paid in India, but none of that money is being taxed by US, the payroll taxes and everything else. So it's not really achieving the objective that the proclamation states it's trying to achieve.
Okay. We have a few more questions, but before that, just for the audience, if you want to ask a question, you can type it in the chat window, or you can, click on raise your hand button so we can unmute you and you can ask the questions directly to Lakshmi Garu. Lakshmi Garu, I think I know the answer, but I'll just go ahead and ask it, right? So if there are parents who have a multiple entry visa, right? And I know right now there are travel restrictions, right, due to the pandemic. So when things get better, they are still able to, fly with the multiple entry visa, right? There is no changes to that effect, right?
Yes. It only affects those people who don't, when they're able to fly. It only affects those people who are either not, well, with the consulates closed, already have a visa in place, really. Because once the consulates open up, that's when it would be an issue.
And so there are two more questions I had in chat. Just trying to frame it properly. So in March, somebody's H1 was picked, right? And they've submitted the documentation. They've not gotten the approval yet, but their OPT is about to expire. They cannot, I believe they cannot travel back due to the travel restrictions. And what does this person do in that case?
Well, there's good news I have for you today is that there's something called the TAGCA. So if you have filed your H-1B petition prior to your, while your OPT, your invalid OPT status, then even if your OPT expires during the summer, then you're allowed to continue working until the petition, H-1B petition, is denied. So if it was picked up and you have a receipt notice, pursuant to the cap gap, you can continue working for that employer. So you're in good shape. So that's nice that I can at least give somebody some good news today.
Yeah, yeah. Thanks. Like two other questions I had. One, so OPT students, they are not affected by these restrictions, are they?
No, no. OPT, because they're not taking any classes, are not, they're only subject to the, they've just got to be careful about the unemployment provision within the OPT and STEM OPT regs.
Okay. The last one I had from the chat was, so universities, as you mentioned in the presentation, universities have filed a case, right? Do you have any latest update on that? I mean,
no, I mean, like I said, they filed last week. They filed almost immediately in Massachusetts, and like I said, USC, University of Southern California, joined, but it's going to take some time. I'm sure they're asking for expedited processing, given the nature of everything. And we are going to be keeping track, and I wanted to make sure that people knew, where am I? That if we've got, our webinar series every Wednesday, but because when you'll be sharing this, I'm sure they'll get the PowerPoint as well, but as soon as something comes out, we try to send it out by update. So I'm keeping a very close eye on how this is translating. And, I spent at least, I'm the only law firm in Virginia that's ever worked for, I've been special counsel for the Attorney General of Virginia for a decade. So I represented the schools and academic universities, and I was thinking of merging with another law firm. And because of a conflict, I had to withdraw representation. And one of the attorney generals in Virginia at that time was Ken Cuccinelli, who's the USCIS director. So I joke with people and tell them that these aren't the things that I had counseled him on. So because of that relationship with the academic community, we're still in touch with them a great deal. And I have been taking questions and I try to answer them as quickly as I can, but we're getting a lot of questions at info@cellalaw.com. And as part of my public service, I'm trying to, even people with other, that have other attorneys that they're working with, I'm trying to answer their questions, no consultation fee. It's my way of trying to help out the community. And I know that immigration is not just papers. It's your life, your kids going to school, you've got whether to buy a house. Late at night, I'm sure it keeps a lot of people up. So we're hoping that through sharing information and through answering questions, we can alleviate their stress just a little bit. So that's what we're trying to do. So if they've got questions, they can subscribe to our newsletter, email us, and I'd be happy to answer them if there's some question that comes up after. And if they do that, we'll be making sure that we update with whatever's happening with this lawsuit with the students. Not only that, to see if there's going to be a legal challenge to the H-1Bs. I know a lot of companies are impacted, and there's a really good Forbes article, if you all haven't read it, by Forbes Canada, that is kind of saying, thank you, United States, for having those really tough immigration restrictions, because we're getting the best and brightest people now. So, I think other countries are benefiting, but we hope that there's going to be, there's definitely, I've been practicing immigration for over 20 some odd years. And this is probably the most difficult time. I mean, even more difficult than after 9/11. But at 9/11, at that time, that seemed to be the worst because we had nothing to compare it to. But it got better. And so I can just see that, you know, this is just a hitch in the process. Hopefully there'll be a change in administration in November and things will get better. But the important thing is that while things are tough, you don't just stand still. You got to keep moving your immigration process forward and, you know, be really responsible about maintaining your status. And then there'll be a light at the end of the tunnel, I promise.
Here we have one more question from Chad. What is the probability pattern you've been seeing on receiving RFE after upgrading to premium?
Oh, you're going to get it almost immediately. You know, we were seeing premium processing RFEs and post, and you know, even pre-premium processing, I think we did because now all that information is public knowledge. But we cross-checked what it was with the national average versus what we were seeing. And the national average was, you know, our RFE rate internally was really low. And we take a great deal of pride in that. It's almost like a challenge to me, right? So I feel like got to get the petition approved without an RFE. As soon as those pending RFEs that we had, I mean, pending petitions that we had were upgraded, day one. Like I said, you can look at the date that it was received. And you have to know that when it's received by the USCIS, it has to go through a process. It doesn't go on the adjudicator's desk immediately. It has to go to the mailroom, then it's sorted, then it goes to the particular department, then in that department it goes to an adjudicator. And that means mostly half the day the petition is going to be in transit. So with that very day, we're getting the RFE issued. So that person didn't have a chance to read the petition. You know, so you are going to see that. But the good news is they're not very strong RFEs or difficult RFEs. So it's something to overcome. It's easy to overcome. They're just being issued because they want to stop the clock effectively. And so if you think about it that way, you won't feel as bad. It's never good to get an RFE, but you know, it's something that can be overcome.
All right, Lakshmi, I think that's all the questions from Chad. Again, I'll just give the audience one last time. If anybody has questions, please go ahead and type it in chat window, or you can click on the raise your hand button.
And we're actually going to be, this coming Wednesday, one of the topics that we're going to be going over is, somebody had requested this, because I tell our audience every week, tell me if there are topics you want to cover. So I'm going to go over in depth some issues that come up on requests for evidence, like how to respond to a specialty occupation, how to respond to employer-employee, you know, what are the issues that are coming up on the RFEs and how to overcome them. So if you either email us or, you know, I think there's a link on there to register for our webinar, we will be going over that in depth, which I think will make you feel better even if you did get an RFE.
Okay. All right, Lakshmi, I think we've reached you know, the top of the hour. I'd just like to thank all the participants who attended today's webinar, especially Lakshmi Garu. Meeru Telugu community ki help cheyalani meere munduku vacharu. Chala, you know, valuable information provide chesaru. On behalf of TAGCA and the participants, I'd like to thank you for your time. You know, have a good rest of the day.
Thank you, Andy. Anytime.